Good afternoon, everybody. This is Jeff Jenkins and Eric Clayman. It's been a little while since we've had one of our Facebook Live programs because we thought we covered just about everything there was to cover.
Right. We started it as a little COVID interlude for the 2 weeks that we would be locked out of the office. Mm-hmm. But it did continue, didn't it, Jeff?
Yeah, it did. We're still not over it. So anyway, what we want to talk about today is in New Jersey, the state government and the federal government, in some cases, have imposed moratoriums on certain things. And they're due to expire at the end of December, just a few days away. And in some cases, things are being done already. But before we start talking about those, I just saw in the paper that, one of the moratoriums was on student loans. You didn't have to pay on your student loan. The interest wouldn't accrue. And that moratorium was supposed to expire at the end of January. So the federal government just moved it till May 1st. So they added 90 days onto that one. The others that we're going to talk about, I guess evictions would be a good one to start with, do you think?
Right. And just to be clear on the student loans, they can't show up on your credit report if you don't pay the student loan.
Right.
So it's an interest-free loan from the government. Jeff, there is a law in place to deal with student loans and other defaulted debts.
Yeah, that's right. It's called the Bankruptcy Code.
And sometimes Congress forgets that which it has already created. Mm-hmm. But besides that, you want to start? Let's talk about evictions. Sure, evictions make sense. That's really probably the one or two or three things most dramatically dealt with by our government as a result of COVID. And it's been a lopsided deal in the sense that we have many clients who are landlords, right?
Yes, we do.
Anytime you help a tenant, and I use that in quotes because you allow the tenant to reside in the property without paying because they can't, you sometimes hurt the other side of that, which is not every landlord is a large real estate investment trust.
That's right. There are many, many landlords out there that might just have their home and one investment property, something like that. And if they don't get the rent, how are they going to pay the mortgage on it?
Right. So let's talk about tenants first, but this is a good topic. So what happened during the COVID moratorium is that landlords were allowed to evict their tenants if and only if they could prove that the property was in hazardous conditions, right?
Right.
Otherwise, they could file a complaint and it was going to mandatory mediation.
Right. And this is just for residential tenants that we're talking about, because it didn't stop for commercial tenants. The eviction rule didn't apply to them.
And there's many, many rules that don't apply to commercial tenants. There's self-help, there's lockouts, there's things like that.
Yeah.
So it's not surprising there'd be separate rules in COVID for residential tenants. But Jeff's right to keep me focused on residential tenants. So what they had was these little arbitration hearings or mediations between the landlord and the tenant. And if the tenant didn't show up, or quite frankly, if the landlord didn't show up, not much would happen even if they did show up. They were given suggestions on how they might be able to work a payment arrangement. But there was no fear of being evicted, and there was no hammer for the landlord to use unless the landlord wanted to say that the property was in hazardous condition. So now we are graduating from that, and we're beginning to see clients who are being evicted, but the original transition, Jeff, depended on the tenant's income.
Yes, that's
which
right.
Sometimes the landlord doesn't even know the tenant's new income. Mm-hmm. So it's very strange. But if the tenant's income was below a certain level, which was
had to be less than 80% of the median income for a household that size
in that county.
Yeah.
So the county income of that size, if the income was below that, then the tenant was protected anyway.
Right.
So if the landlord could prove that he knew or she knew or it knew that the tenant's family had income greater than 80% of the county's average income, then the landlord-tenant action could start.
Yes.
And now, I think, starting this year, that particular delay is no longer in place.
Right.
So we're not going to see as many of the arbitration mediation things. We're not going to see a statement from the landlord that the tenant makes a certain amount of money. And we are going to see landlord-tenant actions. And Jeff, what can we do to help people if they're facing a landlord-tenant action?
Well, we're bankruptcy attorneys, and so we think about filing bankruptcies for people, but it's not always appropriate. Sometimes it's not the right answer, and we would never put somebody in a bankruptcy if we didn't think they really needed it. But if you can't work, if you're in this situation that we're talking about, you're facing an eviction, you should certainly consult with a bankruptcy attorney to see what can be done. They've had programs where they've given landlords or tenants rent money, but they had real problems with them in New Jersey and Pennsylvania. It just, I don't know, it didn't function very smoothly. It would be a way to put it, I suppose.
You're very kind.
Yeah. But what Eric was trying to have me say is that we can always do a bankruptcy if we need to, and you're facing eviction, you're behind with your rent, and you want to stay in your dwelling, whatever it is, a house, an apartment. We can pay the rent arrears through. We would do a Chapter 13 for you. We pay the rent arrears through the Chapter 13 trustee, and you'd resume making your normal monthly rent payments after the bankruptcy was filed.
And the key, of course, Jeff, is the timing here.
Mm-hmm.
You must see a bankruptcy attorney before there is a judgment against you, before the landlord-tenant hearing date. You must file bankruptcy. They changed this law in 2005. And we used to, right? We used to be able to say to the judges, possession is 9/10 of the law. And if our clients were still in the property, it's theirs to keep. And we'd file bankruptcy while the court officer was throwing them out of their house. They'd be hanging on, and we'd file bankruptcy and stop it. That changed. If there's a judgment for possession, a judgment as a result of landlord-tenant court, we can't stop it anymore, except under using extraordinary means, which are
not with bankruptcy. Certainly.
Yeah. So the key here, and Jeff was being modest about how we help people, most people, by filing a bankruptcy petition, but you should always learn your options so that if you receive a summons and complaint, particularly from your landlord, you must consult a lawyer. Chances are your landlord has, and even if they haven't, they've chosen to use court proceeding.
Mm-hmm.
You're silly to try to contest a court hearing without a lawyer.
Right. And even with this moratorium in place, many landlords have filed complaints and sent the complaint and a summons to the tenant, but the summons doesn't have a court date on it. And that's a big difference. Before COVID, the summons would have a court date on there. And what Eric said, we've talked about this before, how important it is for tenants to do something before that court date, because once the judge signs the judgment for possession, there's nothing that we can do with a bankruptcy anyway to stop what's going on.
That's correct. So that's an important. So Jeff, talk about a Chapter 13. So we file the bankruptcy before the hearing date, and then the next month, the landlord will accept regular monthly payments. They have to.
Must. Yep. If you want to keep the lease,
right,
then you would start paying the landlord again, and the landlord really doesn't have a say in the matter. It's federal law, the bankruptcy code, that allows us to do that.
And then we kind of divvy up the arrears over a couple of years, and you make a new payment to a trustee who'll repay the arrears. The meanwhile, you're protected from all your other collection actions, and this might transition us well into utilities, Jeff, because I'm guessing what I was going to say is generally all your other creditors are stopped from collection actions, and generally, not always, we can make sure you don't have to pay back any credit cards, medical bills, driving surcharges, and the like, and utilities. But utilities have always had a special designation in bankruptcy cases. And many people are behind with if you're behind with your rent, you are very likely to be behind with utilities. If you think about it, the things you have to pay are your rent, food, car insurance, and utilities. Those are the basics. And if you're behind with any one of those basics, you're probably behind with many of them. So let's talk about people who are, whether you're behind with rent, behind with a mortgage, if you're behind with utilities, there's been a moratorium that also ends this year, right?
Yes. It was supposed to end when? At the end of September?
Yeah, I think
But
so.
the governor said he was going to give everybody another 90 days to try to work things out with the utility companies. So, for all intents and purposes, it ends at the end of this month.
You're right. It ended September 30th, but the utility companies weren't allowed to shut anything off.
Right.
It was crazy.
Yeah. And of course, this doesn't change the rules that have been in place for a while, where if you're below a certain income level, the utility companies can't disconnect your heat source during the winter months. And I want to mention one more thing about the landlord. I'll just skip back
Sure.
to the landlord-tenant situation. It may be that if you're a tenant, you don't want to stay there anymore. And because we've been talking about like as if you want to remain there. If you want to leave, you're going to owe the landlord a lot of money unless you pay him. And so if that's the case, we would look at perhaps filing a Chapter 7 and just erasing your liability, which could be pretty significant. I mean, you could have not paid rent for almost 2 years.
Right. And again, most of our clients who come in to see us to do a Chapter 7, if they're behind with their rent, they're ready to move back in with family often, or find a less expensive place to live, or they just never liked where they were living, and this gives them a fresh start. But if you're behind with your rent, you probably have other bills. And Jeff, we have ways to help people with credit reports, getting a credit report, and making sure that they get all of their bills. The key to a successful bankruptcy is to include all the bills, clean everything up, so you'll get that fresh start that Congress promised you.
Yes, that's exactly right. And we're back to utilities, I guess. And if you file a bankruptcy, what the utility companies will do, whatever you owe them when the bankruptcy is filed, we can erase, or you can pay some of it back. It just depends what's going on. But the utility company will leave that account alone and create a new account for you for the service that you use after the bankruptcy is filed, which of course you need to pay for. And if you don't, then you could have a problem.
But the bill is much smaller than it was before.
Yeah.
Everything going backwards is just zeroed out, more or less, to keep things simple. And everything going forward, it's your responsibility, just like rent, and just like a mortgage, quite frankly. Excuse me. The beauty of a bankruptcy is you're transitioning into the fresh start. So the moment you file bankruptcy, especially a Chapter 13, but either one, you then have to take responsibility to start paying your rent again, start paying your mortgage again, or start paying your utilities again. But what got you into the problem beforehand, we're going to help you fix that problem. And one of the fixes is you don't have to make this huge payment to catch up on any of those bills.
Right.
So it really does help people. Most people who fall behind with their rent or utilities have had a catastrophe, a catastrophic event that caused them to fall behind. Unemployment, illness, divorce, something. But these catastrophic events for most of us do end. Not for everyone, but for most of us do end. But you're still left with what the event caused. Our jobs as bankruptcy attorneys is to make sure the path going forward, you won't have that catastrophic event pulling you down.
Eric, why don't we talk about foreclosures and sheriff sales? I think that might be next on the list. There has been a moratorium on mortgage companies conducting a foreclosure, generally for most government-backed loans where the United States government guarantees the loan. And that takes care of about 70% of the mortgages that are out there. The The other 30% are not backed by the U.S. government, and we never did anything in New Jersey to stop those companies from doing a foreclosure. They just didn't do it. And one of the reasons is, well, a couple of reasons. I think that maybe they felt that it would be a political faux pas to be foreclosing when other mortgage companies couldn't. And we had the no eviction rule in place. So even if they did a foreclosure and could have a sheriff sale, and that's another matter, the sheriffs in New Jersey generally stopped doing normal residential sheriff sales. They didn't. They just they conducted commercial foreclosures, or if the property was unsafe somehow. But for the normal person who's living in a house and they're behind with their mortgage, the sheriffs had no sales. But they're starting to do that again.
Yes, they have. They already have started sheriff sales. And I guess, Jeff, beginning in January, we're going to see a rush of foreclosures of the government-backed mortgages, right?
Yes.
That's going to start. Again, the foreclosure process in New Jersey is judicial. It's legal. It means that there's a summons and complaint. A lawsuit is filed. If you receive a summons and complaint, your mortgage company has hired a lawyer. You need a lawyer to help you as well. That's the first step. Second step is at the end game. We have to file, if you choose to file bankruptcy, and we can talk about that in a moment, but if you file bankruptcy, we have to file before the sheriff sale. It's very important. Again, that was changed in 2005 as well.
Yes.
That possession 9/10 of the law thing was.
That doesn't work anymore.
Yeah, it used to be such a great way to practice bankruptcy law, but they really put some handcuffs on us. Anyway, if you receive that newspaper clipping that there's a sheriff sale against your residence, you must speak to a lawyer right away. It's better if you speak to an attorney as soon as you get the summons and complaint, but you must speak to an attorney before the sheriff sale date, because after the sheriff sale date, a bankruptcy can't help you. And you should have certain rights under New Jersey to pay under New Jersey law to pay the whole balance off, but some of the rights are just, they're theoretical more than they are practical or realistic. So, Jeff, what do we do for people as bankruptcy attorneys if they see us and they've just received the summons and complaint in foreclosure, and they want to save their house?
Yeah, If you want to stay in your house, then we can certainly file a Chapter 13 for you, and it would be very similar to the rent situation. Whatever you're behind on your mortgage, we can pay through the Chapter 13 trustee over time, and the month after we file, you have to start paying your mortgage again.
And the mortgage company has to accept it.
Yes, must. Yep, that's right.
And it really works. We've helped tens of thousands of people save their home, right? Did we ever do the math and figure that out?
Well, that's a good
tens
number.
Of thousands of people have saved their house through Chapter 13 that we have filed. And I guess over the last, would you say 10 years, the mortgage company, in addition to doing what Jeff just described, the arrears cure bankruptcy, the arrears are cured over 5 years, 3 to 5 years. We also see mortgage companies willing to do loan modification, or what they call loss mitigation, through Chapter 13.
Mm-hmm.
Basically, what that means is they see that you're serious, that you're saving your house. You filed bankruptcy, you're resuming payments the next month. Rather than do a arrears cure, they might rewrite your mortgage and allow you to keep it, keep your home through a new monthly mortgage payment. And then we just reduce the trustee payment, convert your case to Chapter 7. There are many tools in our toolbox as long as you see us before the sheriff's sale date.
Right.
I don't want to get too far into the weeds, but basically I just wanted to try to explain to people, Jeff, that there are many, many options available, even if you're behind with your mortgage loan. And even if the mortgage company can now start with a summons and complaint.
Right.
If you want to keep your house, we can help you.
Yeah. And of course, during this moratorium on foreclosures, the mortgage companies have given forbearance agreements to a lot of people.
Yes.
And told them, you don't have to pay your mortgage right now. That's ending. or has ended, but certainly at the end of this month, it's over with. And the mortgage company doesn't have to do any special deal with you once you're required to pay that money back. They could ask for all the money now, or if they could put it on the end of the mortgage loan if they want to, or like Eric was talking about, they could do a loan modification where they might not just combine it with what you owe, the arrears with what you owe. They might actually change not only the term of the loan, but also the interest rate to try to keep your payment affordable.
Right. If you are in a loan forbearance agreement, it's very, very important that you keep in touch with your mortgage company at least twice a month so that you understand their requirements, they understand your ability to pay.
Mm-hmm.
We recommend you call them twice a month. They get the name of the person you're dealing with. It's very, very important.
Yeah. Now, Eric and I have talked about these things probably a number of times really in our Facebook Live presentations, but we thought it was appropriate to do it again this week, and we're going to have another Facebook Live next Thursday at 2 o'clock to go over with people what this means. The moratoriums are over with, so what can you do? And we're giving you some ideas about what you can do, and also what the consequences are potentially if something's not done.
Right. That's the key. Do something. Because it's very uncomfortable if you're behind with your mortgage, behind with your rent, behind with your utilities. We know it. We hear it all the time. It's very uncomfortable. But just pick up the phone, give us a call. We're here to help you. There's the phone. I love when they do that. Pick up the phone. There it is.
Yes.
Awesome.
Richard's right on the ball.
Yeah.
So I think that concludes our program for today. If you've been watching, thanks for tuning in. And we'll see you next Thursday at 2 o'clock.